Without interrupting my learned friend, I just want to. There's some part which is missing in our. I try to upload it I can share with the lordships. Right.
Yes, Mr. Salve.
Yes. But I'm only to, as my note said, I'm only supplementing some of the submissions which have been made already. And I've just picked up the issues. One is, the construction of the proviso to sub-article 3 of 370. The attorney has addressed your lordship at length. Only a few points to add to what he has said. The width of power under Article 370, because that has been the subject matter of some discussion. The nature of the power exercised by President under various sub-articles of Article 370, there was a suggestion made that this might be executive in nature. The absence of a challenge on administrative law principle of abuse of power. It's necessary to get a few concepts in their right perspective. The exclusion of judicial review beyond the question of competence, questions that are political in nature. And the use of power under 356 to make changes that may be irreversible. And finally, the violation of basic structure. A very short submission in each of these headings. The first point, my lord, relates to the construction of the proviso. Your lordship have heard detailed submissions by the solicitor and by the attorney. And my lord, I just want to put it in a frame. So normally, these are the three aspects which one would look at: the textual, the contextual, and the historical. We have, my lord, and the solicitor read it out to your lordship. The author of the provision and the list of dates given by the solicitor sets out in detail the confabulations, including differences of opinion on whether there should at all be a special treatment of Kashmir. Then, my lord, Gopal Swami Iyengar's draft, its brief discussion, and its adoption by the Constituent Assembly. And one thing was clear: this was an element accommodating certain compromises, political compromises within the constitutional framework. Your lordship has read all of that. I'm not going to repeat reading any of that. But that has been sufficiently put across. And it now stands as it does. And its words have to be given their plain meaning. So, my lord, the first thing your lordship would do in my respectful submission is the textual bit. Now, in the textual bit, what is of great significance, and this point has been put, if the idea was that the president could act only to give effect to a recommendation of the Constituent Assembly, then that would have been made the precondition for exercise of power. Perhaps the article would have said, if a recommendation is received from the Constituent Assembly, then the president may. And your lordship, in fact, in the course of the hearing, my lord, the Chief Justice gave the example of certain other articles where it says, if a reference is made or if something is done, then. But that's not the frame in which this was drawn up. One of the articles, my lord, of that kind is 249. Merchants are very well familiar with that. It starts by saying, if the Council of States has declared by resolution, then it shall be lawful to make laws. So that is a precondition for the exercise of power.
But Mr. Salve,
Yes.
Does the proviso to Article 370 bracket 3 does not bring about the same result
Yes.
by the use of the expression shall be necessary?
Yes. So, my lord, shall be necessary here must then be subject to the principle that if there is a constituent assembly, then it's first of all, the word is recommendation, not concurrence. And secondly, that becomes necessary because if there is a constituent assembly, then you cannot act in vacuo. That was, in my respectful submission, the textually, because my lord, we must first of all discern legislative intent out of language. And from the language, when the Constitution knows, or the drafting of the Constitution, the authors of the Constitution knew that there were certain models in which it says, if something is done, then you may exercise a power. Is the president to act, my lord, only to give effect to the desire of the Constituent Assembly, or is he to receive a recommendation from the Constituent Assembly? And obviously, the compromise was he must receive a recommendation from the Constituent Assembly, which obviously means if there is one, he must. Secondly, my lord, this very article, and we are all this is textual. This very article uses two separate expressions. B2 uses the word concurrence. I mean, it's a point which has been already made. And the proviso uses recommendation. Now, if, my lord, one had put concurrence here, the argument would still remain, but it would have been a much stronger place for the Constituent Assembly. So while, my lord, distribution of the fields of legislation in subarticle B of in clause B of subarticle 1 was put as concurrence of the government of the state. At the same time, subarticle 3 used the word recommendation. It's not an amendment, it's not this. So, my lord, one must assume, and this was a article which had internal dissensions and differences, and it was very carefully crafted between within the committee and within the assembly. There were differing points of view. So, my lord, we must give meaning to every word of this article. So the difference between concurrence and recommendation and its framing as a proviso. At two places, again, subarticle 2 says, if the concurrence. So, my lord, this is a very conscious departure from the concurrence, recommendation, consultation, recommendation, concurrence. One would perhaps say the difference is, if you fail to consult, it is not fatal. If you fail to obtain a recommendation, if a recommendation is necessary, it is of more serious consequence. Would it be fatal? I don't know. Concurrence, obviously, because concurrence, then your power gets hedged in. And this is all textual.
So, Mr. Salve, there is one countervailing consideration
Yes,
which we
yes.
possibly may have to bear in mind,
Yes.
that where a change in the distribution of legislative power was envisaged,
Yes.
the provisions spoke of concurrence,
Yes.
except in the area which was covered by the instrument of accession.
Yes.
The exercise of the power under the proviso to clause 3 brings about a complete abrogation of status.
Correct.
Abrogation of 370.
Yes.
in which case all the limitations which are even introduced by the earlier provisions of clause of Article 370 are lifted,
Yes,
including the concurrence on the distribution of
yes,
legislative power,
yes,
consultation.
yes.
Now, could it have been the intent that you require the concurrence for altering the distribution of legislative power or for altering any other provision of the Constitution, but for abrogating the article itself, nothing more than a mere recommendation is required?
Which, my lord, drops me, I'm deeply obliged, my lord, which brings me to the second, the
The
contextual.
power under the proviso is exercised,
Yes,
then there is no limitation at all.
absolutely. And that, my lord, brings me to B, the contextual. And in fact, that was the direct intent. And your lordship will see it from another point of view. There's another point of view. Till the arrangement is in place, unlike other states, where the constitution sets out legislative powers in the seventh schedule in absolute terms. And you need a very elaborate mechanism to tinker with those seventh schedule. It has to be with 50% states voting, etc. Your lordship knows the difference. Here, there was a political agreement and the whole circumstances, including, as Mr. Anger spells out, the specter of the United Nations, which today is, of course, irrelevant, but at that time was very relevant, the problems in the state. So there was a agreement which is embodied in B, which has concurrence. But if this led to a situation which ultimately prevented the purpose of 370. The purpose of 370 was not to create a permanent divide in the constitution. Lots of material has been shown to your lordship on this. It was a phased integration. I'm going to deal, Manoj. Dr. Dhawan has raised a very interesting point of asymmetric federalism, whether that became part of the basic structure. I'm going to deal it separately. But the historical material available to a court, and we have, Manoj, unlike certain other courts, we have always looked at historical material, especially for articles like this. There was a safety valve in sub-article 3 that if the political compromise in sub-article 1 fails to achieve the purpose, at any time it might become necessary to pull the plug. And sub-article 3 is that plug. Now, if one looks at it that way, the whole thing falls in place. The framers of the Constitution kept with the President the power to do away with this special arrangement.
Yes.
And history bears testimony to the foresight and wisdom of those, despite the criticism at that time and the political debate which must, in a democracy, you must always have the noise of a democracy, Mr. Bhutto used to say. The noise of the democracy is the most essential element of a democracy. So this has been the subject of debate. But your lordship has seen the entire history of how phase by phase this has been narrowed down. The divide has been narrowed. More and more subjects were added. More and more alignment was brought about. Because, my lord, the historical perspective of 370 is very important. The troubled relations. While there's always was a hope that the relations with the neighboring country would be on good terms. The history of Kashmir did give rise to apprehensions. And the Lordship has seen all the material. So, border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase it in, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the historical background or the plain text?
The context is that this read by itself, forget the history, this read by itself shows that in sub-article 1, there is a divide in the legislative list base aligned to not the constitutional general 7th schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. And a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And my lord, the history of this provision also tells us it may be difficult to find a logic in each of these because these were a political compromise. Why was the Constituent Assembly put there? That was a compromise. A lot of things are done to assuage ruffled feathers. There were 2 approaches. One was the jackboot, saying doesn't matter, things will settle down, don't agree to anything special for Kashmir. The other was the other extreme, saying if the legitimacy of the accession is being questioned and there is a popular uprising, accommodate that. This was the compromise. So, my lord, one cannot search for too much logic. This was the compromise form. And we must therefore, my lord, the safest thing for a court, in my very respectful submission, as a matter of constitutional interpretation of such provisions. And such provisions are essentially political, and I don't mean political in its pejorative sense. I mean it political as in its constitutional sense. The court has always said you must give it the widest possible meaning. In fact, my lord, I'll give your lordship that passage. Justice Pandian, I think Justice Pandian, in his majority opinion, where he upheld the abolition of the privy purse, where your lordships upheld the abolition of the privy purse, he says that our constitution was meant to be flexible in these areas. I'll give your lordship the exact passage. The fact that the ground realities would change in Jammu and Kashmir and 370 would accommodate was, my lord, first recognized by your lordship in the Makbul Damnu case, which has been cited. The challenge brought where Mr. Garg argued that without the Sadr Riyasat, you could not have the preventive detention law. And your lordship said state means state as exists from time to time. That is, my lord, already there. I'll give your lordship the passage 72-1 Supreme Court cases 536.
You have given us para
It's
28
there, my lord. It's volume 1 CLC
and
PDF.
you said para
36.
28 there.
Para 28. So this was already one example of how this evolved. And that, my lord, backs in with a principle of construction. Your lord, the attorney just cited the presidential reference case, which says, well, if there is a requirement, then if there is a constituent assembly, you must get the recommendation. But if there is no constituent assembly, are you denuded of the power? And the presidential reference, my lord, the attorney just gave your lordships a moment ago. The judgment based on a passage on impossibility. And your lordship cited with approval Craze on Legislation, the 6th edition, in the presidential reference. The attorney just gave it, my lord. The
Yes.
attorney just cited it. I have, my lord, for your lordship's assistance, given the 9th edition of Craze. I believe it's attached to my submissions. There's some slight interesting change in the text. I believe it is at PDF page 37.
Mr. Salve, which is your compilation of it?
Well, it's. I believe it has been given along with my note.
Is it along with the note itself?
Yes. This is, my lord, from the 9th edition of Craze. It's called Disregarding the Impossible. Para 8.2.9. It is appended to the note.
What page did you say, Mr. Zari?
Page 37 PDF.
Yes. Disregarding the impossible.
Yes. Yes. There's a slight difference in text from what your lordships approved, and in fact, it's even more instructive. It says one of the ancient maxims of common law is lex non causa ad impossibilia. As Broom's legal maxim puts it, the maxim, or as it is expressed, impotentia excusat legem, must be understood in the qualified sense that impotentia excuses, where there is a necessary or invincible disability to perform the mandatory part of law or forbear. It is akin to the maxim of the Roman law, nemo tenetur ad impossibilia, which, derived from common sense and natural equity, has been adopted and applied by the law of England under various and dissimilar circumstances. The result of the application of the maxim, which remains potent, is that the draftsman need not expressly excuse that compliance, which is obviously impossible. So, for example, if requiring a particular communication to take the prescribed form, the draftsman need not generally state that the requirement can be lawfully ignored where no form has been prescribed for that purpose. There may be occasions, however, where the sense of the legislation makes it arguable that the primary provisions are not to operate at all until certain mechanisms have been put to place by subordinate legislation. If the draftsman thinks it is necessary to avoid a suggestion of that kind, he will generally qualify a reference to the prescription by, if any, of that kind. So, my lord, the principle is very interesting. In fact, we have used it in a different branch, my lord. In service law, for example, we've used it all the time. it says your promotion will be as per rules. Now, if no rules are framed, doesn't mean you won't get a promotion. Then you follow whatever is the general principle. But if there are rules, they must be strictly followed. Oh, my lord, this was the argument in this court. Of course, I went through the judgment. It didn't get to that point of deciding it. The old, my lord, section 80J, rule 19(1)J, and the argument was, for example, if it says deduction of capital employed, if there are rules, you follow them. If there are no rules, doesn't mean the exemption fails. But there are other provisions which says you will get such other deductions as rules may provide. And that you can't operate unless there are rules. So we have had, my lord, these two formats. And that is why we come back to why did the framers of the Constitution not say that if the president receives a recommendation from the Constituent Assembly, then he may. And instead say the president may abrogate this article, provided if he gets a recommendation from the Constituent Assembly. Which if there is one, you must get the recommendation, otherwise. Now, my lord, this was also made.
Just 1 minute.
I'm sorry.
Mr. Salve, I think perhaps we'll just wait for a second, Mr. Yes, Mr. Salve. Mr. Salve? Voice is perhaps, for a moment he was...
Now, my lord.
Yes, Mr. Salve.
Yes. Can your lordship hear me, my lord?
Yes, we can hear you now.
Yes. Finally, my lord, look at one important nuance of this article.
Yes.
In subclause D of clause B, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. So, power to the President to apply or disapply provisions of the Constitution or apply them with modifications. And this does not require unlike B1, that is the spread in the list, concurrence is not called for.
Let's look at it now, Mr. Salve. Let's see that again. I don't.
Yes. If your lordship sees 372(1)(b), 1 is the spread, my lord, of the list. Small subclauses 1 and 2 is
corresponding to the IOA.
yes.
That requires consultation.
That requires concurrence. That comes in through the first proviso.
B.
Proviso, no such order which relates to.
Requires concurrence.
Yeah, B1 requires concurrence, consultation.
No, consultation.
Correct, my lord? And no such order which relates to matter other than those referred to shall be in the concurrence of the government. So this was built in. This dichotomy was built in there itself. Now, two things, my lord, your lordship will note. Applying or disapplying provisions of the Constitution.
No, Mr. Salve, I could not get this argument.
Yeah, yes. May I just restate the point, madam? Clause D relates to not 370 but other provisions of the Constitution.
Absolutely.
And they can be applied, disapplied, or with such modifications as the President considers appropriate. And that is with the concurrence of that government.
Yes.
Correct, madam? And sub-article 2 says, is the concurrence referred to in paragraph 2 of B of clause 1, such other matters, or in the second proviso, that is, my lord, would be D, be given before the Constituent Assembly for framing of the Constitution, it will be placed before the Assembly for such decision as it may take thereon. So this was meant to operate much beyond the Constituent Assembly also, because that concurrence would continue forever. There would always be a state government. But state government, what that state government is another matter. There would always be a state government. But disapplying 370 was carved out and put in 3. Now that can't be a provision limited in time to the existence of the Constituent Assembly. And that is what explains perhaps why the recommendation rather than concurrence.
Mr. Salve, your voice was cracking just a little bit, when you were making this, the last part of your argument.
Yes.
Maybe.
I'll repeat it, Marat.
Yeah, if you could.
Disapplying 370 itself comes under sub-article 3.
Right.
And that is why perhaps the framers of the Constitution scaled it down to recommendation instead of concurrence. And that to put it in a proviso that when there is a Constituent Assembly, during the life of the Constituent Assembly, if you decide to modify 370 or disapply 370, because the whole purpose of the Constituent Assembly was to work to try and find this area of accommodating both.
That's
So if
fair
I,
enough. Mr. Salve, we got your point.
Yeah,
That
that's
after all, this is a proviso.
yes,
It uses the word recommendation and it does
Yes.
say if there is a recommendation. We got that
Yes.
point. We got that line of argument.
I was just closing it by saying,
You're making just a little while ago
yes,
was that you began by saying that B1
yes,
requires consultation. Matters in the list other than those covered by the IOA requires concurrence. That is B2. Then we went to D.
yes,
D says, subject to such exceptions and modifications as the President may order by order specify.
yes,
There also there is a bifurcation.
yes,
Matters which refer to the instrument of accession require consultation. Other matters other than those governed by the instrument of accession require concurrence.
correct. Now, the point which I was making, perhaps
That's
that
the
got
point which
lost.
we wanted you to just come back
Yes.
to again. Yes.
So again, my lord, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
No, where do you say that? How do you say that?
Because, my lord, instrument of accession requires consultation, not concurrence. The first proviso.
Subjects are so important. Convenience.
Why this dichotomy in the first and second proviso, my lord? Your lordship would have to reflect over. And that also, my lord, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
You know, Mr. Salve,
Yes.
clause B of 370, 371B
Yes.
does not relate to the power to make adaptations, modifications, or exceptions at all.
Yes.
What 371B says is that of all the items in the three lists, the president, the power of parliament to make laws would be limited by specific matters.
Yes.
So you take the matters in the list as they are, and then you define what would be the domain of parliament to make the law. There's no power to make exceptions or modifications in clause B at all.
No,
And
not at all.
bifurcate, you correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because
Yes.
these matters clearly specified in the IOA: defense,
Correct.
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation with the state government was required,
Yes.
because they were specified in black and white in the IOA.
Correct. But
Matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
and my lord,
Now, when it comes to
yes.
D is not just specification of matters. D is making exceptions or modifications.
That's right.
There again, they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
Consultation.
only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And my lord, one cannot miss the significance, what I wanted to add, of the overlay of the principle of international law, which is engrafted in 363. That these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the president had the last word. And that philosophy is reflected in sub-article. That if you want to completely disapply this political arrangement, if there is a Constituent Assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you're trying to drive at is that clause 3 of Article 370
Yes.
is absolutely on the same is on the same
Philosophy.
trend, or is the same platform
Yes.
as clause B1 and the first proviso to D. You're trying to equate the power and the substantive part of clause 3.
The underpinning is the same, my lord.
Power
The
under
underpinning is the same.
the first proviso to D and B1.
Yes. And because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the Constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the president instead of driving one to Article 368. They reserved the power in the president to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent. The executive, president is executive government, where the executive government can disapply a provision of the Constitution.
The only internal problem with that argument, Mr. Salve, we'll reflect on
Yes.
it during the research in the next hour,
Yes.
that where the power to do something lesser in terms of constitutional impact is hedged in with restrictions, namely the power to make exceptions and modifications, can we subsume that the power to have something greater, which has
Yes.
greater constitutional impact, namely the abrogation itself, will be bereft of all limitations?
My lord, to which my respectful response is, there is a compromise. I keep in my control, because the accession is complete. So what are the understanding? It's a part of India. 1 and 3 apply. It's an Indian state. But I have a political compromise in which sub-article 1 has how it will operate. That's the compromise. But sub-article 3 is to put the compromise to an end. And I reserve that power.
Mr. Salve, we are almost at the anvil of lunch. Just
Yes.
one, maybe one of the juniors can do it here in the court as well.
Yes.
Found which were those matters governed by B1 and which were the matters governed by B2. B1 basically covered the 3 subjects.
Yes.
Now, which were the matters in the IOA to which the first proviso to D applies?
We'll not try and respond to that at 2 p.m.
So we'll,
I see that. I see that.
that will give us some insight on what was the intent of.
Yes. I'm deeply obliged. We'll do that.
So many articles that deal with defense, which are covered by the instrument of accession.
Well, Lord,
That list is given.
Lord, I had in my list of dates, Lordships would recall the sub-article A1 says that the president would demarcate which entries fall within those 3 areas. So there was a specific order passed, possibly the first order.
48 or 54.
Yes, my Lord, which 50, my Lord,
50, 50, 50.
which
54
because
then.
communication would have telecommunication, postal communication, etc., etc. So three
So
entry.
which were the other articles?
No, we'll respond to that at 2.
Because the
My Lord, in fact, I'm grateful to my Lord the Chief Justice for the steer. If your Lordship sees the instrument of accession,
yes,
and this is in document 1, volume 1, sorry, page 9. Your Lordships have it?
yes. Just one second.
Yes. My Lord Justice Suryakant has it. If your Lordship sees this, very interesting.
Page 1. Sorry, page 1.
Clause 1 is the accession.
Yes.
He says, I hereby declare I accede to the dominion with the intent that the Governor General of India shall by virtue of this, my instrument of accession, but subject to the terms and for the purpose of dominion, exercise such functions as may be vested by them in the Government of India Act as in the Dominion of India on the 15th day of August. I hereby assume the obligation of ensuring that due effect is given to the provisions, etc. Now look at 3, man. I accept the matters specified in the schedule as the matters with respect to which the Dominion legislature may make law for this state.
So this is B1.
Yes.
This corresponds to clause B1.
Yes, my lord. And this was in a schedule which I'll show your lordships in a moment. I hereby declare that I accede to the Dominion of India on the assurance that if an agreement is made between the Governor General and the ruler of the state whereby any functions in relation to the administration of this state of any law of the Dominion legislature shall be exercised by the ruler of the state, then such agreement shall be construed and have effect accordingly. Now, my lord, comes the most important thing. In 6 says nothing in the instrument will impart dominion to make any law authorizing compulsory acquisition. Now, this is interesting. This is a carve out from the legislative list principle. But I hereby undertake that should the dominion apply, etc. Now, my lord, 7 is important. Nothing in the instrument shall be deemed to commit in any way to the acceptance of any future constitution or fetter my discretion. And nothing in the instrument affects the continuance of my sovereignty and over the state, save as provided under the instrument. Now, this was the instrument of accession, but the Constitution finally, if the Lordship now matches this with 370, and I'm sorry, my Lord, for completeness, the schedule your Lordship will find in volume 4, page 176.
So basically defense, external affairs and communications.
Correct. Now, my lord, what happened? But what the spread in 370 corresponds to is very important. 370 starts by saying the Part B provision will not apply. 238 will not.
Right.
Then it says the power of Parliament to make laws shall be limited to those matters in the Union and the concurrent list which in the consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession. So this was on the issue of the legislative list and that schedule. Matching them with our 7 schedule, and the president would decide how the 7 schedule is to be divided. And here it's only consultation consistent with the philosophy that accession and instruments of accession, these are what are in international law called political documents, not political in the political sense, political documents.
I think, Mr. Salve, it's very clear now. If the president wanted to make any exceptions or modifications
Yes,
in respect of defense, communication, or external affairs, then only consultation was required.
correct. Now,
That is
my lord,
of the first proviso to clause D.
correct. Now, my lord, applying other provisions of the Constitution, and my lord, I don't have to give your lordships a catalogue of which are the other provisions. I mean, there are so many important provisions of the Constitution. They would be phased in and applied under D.
Right.
And for that, they said concurrence.
They would require concurrence.
They would require
Yes.
concurrence.
They referred to either defense,
Correct.
the
My lord, the
defense,
legislative
external
lists,
affairs or communications.
broadly, let us say the legislative lists are put to one side because that is really power to make laws.
Yes.
But my lord, institutions, your lordship's jurisdiction under 32, for example.
The Constitution also, yes.
Your lordship's jurisdiction under 32. Should it extend or should it not extend to Jammu and Kashmir? These are, and what about public service commissions? What about election commissions? So on and so forth. So, my lord, all those were provisions to be applied if necessary with adaptation. Now, my lord, what is important? And I come back therefore to my point. How does this align with a complete accession? Article 3 is the answer. That this is an arrangement for the phased introduction of the Constitution, keeping or reserving unto the president the power to disapply this article. Now, obviously, for that, there cannot be concurrence. So it makes sense. Recommendation if there is a constituent assembly, otherwise, the action of the president. This was the arrangement, this was the compromise. And my lord, this compromise was not just with the state of Jammu and Kashmir, the solicitor has placed before your lordships the sharp differences of view even in the Congress Working Committee. They rejected this plan. First time when Shri Gopal Ayangar presented it. Sardar Patel's letter is cited in the solicitor's list of dates. He said, sorry, I don't accept these. So there were, this was a very matter with more than one point of view and competing points of view. So this was the compromise formula, which is incorporated here in the Constitution. This was the workable arrangement. This is all right. Ultimately, we will decide and we will keep to ourselves the power to disapply this article. But if this works phase by phase, introduction of the Constitution, why not? And it did work to a large extent. So one of that principle, which my lord the Chief Justice was pleased to put to me, about lesser power and larger power, would it not require greater safeguard? That would not occur. That's what I call the contextual argument. I'm not finished with this, and I have eye on the clock. If there's anything more, I can assist your lordship on this point. Otherwise, let me move to my next point.
You can move. I think we can move to your next point, Mr. Salve.
Yes. Second point is, my lord, there has been some arguments about even if 370 applies, because no radical change, and Delhi laws was cited. Now, my lord, some cleaning up because some principles need to be clearly stated. the Birla cotton mills in Reed Delhi laws, the power to extend laws. You cannot make a radical change. Well, that can have no application here. That principle can have no application here. Because your Lordship has seen those cases. Your Lordships read down the power to extend and apply laws under Article 14. The argument was excessive delegation. You have conferred upon the executive the power to change a law made by Parliament and its application. And that is why your Lordship said we read it down. That the philosophy, the basic policy of the law cannot be changed, radical changes cannot be made. My Lord, 370 is a part of the Constitution itself. There is no question of excessive delegation. This is a power conferred on the President. And that is why my Lord Lakhanpal rejects this approach. But I was giving your Lordships an answer on first principles.
Yes.
The power, my Lord, under 370 is plenary in nature. And this is a power conferred by the Constitution. A plenary power is not subject to the principle of, or is not amenable to a challenge of excessive delegation because the Constitution has made this delegation. Where Parliament makes a law which is subject to Article 13, or where the state legislature makes a law which is subject to Article 13, then Article 14 challenge can be brought saying this is excessive delegation. And all the Delhi laws, in Reed Delhi laws downwards cases, all dealt with excessive delegation in statutory provisions on the anvil of Article 14. It is completely irrelevant to 370. Your Lordship has already said this in Puranmal, but I wanted to just put it on first principles.
Yes.
The second Malad point is that the power exercise is legislative in character. I don't think I need to belabor that point very hard. Applying provisions and disapplying provisions, modifying provisions of a law is legislative in character. I don't think I need to cite authority for that matter. To suggest that this is an executive power is like saying ordinance making is executive power. And it is done by orders, Malad. I'll just give your Lordship a citation. The Meghalaya case, with Schedule 5, for example, of the Constitution. 1972, one Supreme Court case is 148, just for reference. Where your Lordships have said that, because there also the President can by order say this and by order say that. You're not saying. So this is now what follows from a plenary power and a power which is legislative in character. It has a direct bearing on the next issue of the extent of judicial review, of the exercise of that power. Because that, my lord, logically takes me to my next point, that the Ajit Mills principle, as Justice Krishna had explained in Ajit Mills. In the context of a law made by Parliament, if you say this is abuse of power or collective legislation, it's an argument of competence, not of motive. That is, my lord, the Ajit Mills principle. Your lordship knows when the first law was made, saying if you've collected illegal sales tax, which is not chargeable, if you've collected, you pay. The argument was this is colorable legislation because you're taking away. And Justice Krishna's answer, my lord, I'll just give the page and para numbers, 77 4 SCC, page 98. My lord, this is attached to my note.
Page?
My lord, this is attached to my note starting from page 6. Page 4, sorry. And the relevant paras.
But Mr. Salve, even if it is a legislative power,
Yes.
as you say it is, and probably it is, it's amenable to judicial review on the ground of Article 14. A legislative power cannot be challenged on the ground of malefides. For instance, you cannot
Exactly.
say that Parliament did something because of a malafide intent, because you don't attribute malefides to a collective body of individuals. That's the reason for it.
That's correct, my lord. More than that,
Nagaraj, when they reduced the age of retirement, our court said you can't challenge the reduction in the age of retirement on the grounds that Parliament was acting malafide, because it's a collective body. Malafide is something which you attribute to an individual.
more than that, my lord, your lordships have always said, where it comes to colorable device, supplementary, and all these, as it is, my lord, explained in this judgment,
Actually, they started
it
that.
is really a competence argument.
Colorable exercise of power in Tulloch, our court said, it really means that though
Competence.
you are purporting to exercise power under one entry, you've
Yes.
actually transgressed into another entry. So it's really
That's-
a question of absence of power, legislative.
It's a competence argument.
The competence argument.
Yes. And it's not the Wednesbury unreasonableness.
But equally, Article 14 would be attractive.
My lord,
You have to
14
still meet the test of Article 14.
My lord, 14 can have no application to an Article 370 sub-Article 3 situation. Of course, legislative power you can, if you make a rule which is plainly discriminatory, you can strike it down on violating 14. Of course. Because if Article 13 applies, the whole panoply of fundamental rights apply.
But therefore, assuming that this is a legislative power, it is not immune to challenge on the ground of violation of fundamental rights.
Correct. Fundamental rights, whether a 370 sub-Article 3 disapplying Article 370 is at all amenable to fundamental rights, question mark. I'll address your lordship for a minute on that. Because this is a relationship between the union and a unit of that union. We are now units of that union.
They may be parts of that relationship which create rights in favor of individual citizens.
But if it affects an individual,
A classical part of that, the provision of the on the right of residence. An individual, for instance, can say that I and people belong to my class have the exclusive right of residence in this state. By bringing in others, you are affecting my right under Article 14. Whether there is substance or not is a different thing altogether. But it's amenable to that challenge. You can't say that the challenge is immune.
my lord, I would respectfully submit, applying or disapplying the constitutional provision would not give a individual citizen a right, because I'll tell your lordship why. This takes us back to the basic principle of this is adjusting the accession. Now, my lord, in international law, for example, a citizen can never assert that I had certain rights under an earlier legal regime, and now there is an accession those rights should be continued. Your Lordships have rejected that, consistent following the principle of international law. You have only such rights as are available to you within the territory. Now, in that, if there is a discrimination, you can challenge. Today, my lord, which constitutional regime will apply in Jammu and Kashmir is more, in one sense, almost a constituent power. So, my lord, Article 14 challenge on the ground that I was a citizen, I was living in Kashmir, nobody else was allowed to enter here, now you've taken away my rights. That argument will not be open.
That's quite apart from, of course, the submission of the solicitor that by the abrogation, you expanded the panoply of rights which are individual, which an individual in Jammu and Kashmir has. You have
No,
not
I'm not
restricted
taking
that.
an extreme case. Can an individual come and say, I had a right to live here, splendid isolation. You've taken away that right and now all Indians have the rights, which I earlier had as a special right.
Your contention is that the residents' right to live in Jammu and Kashmir is not taken away.
Nothing. Their rights are expanded by applying the whole of the Indian Constitution. Nobody has a vested right in a state of governance in that sense. And Malad 370 is a part of the Constitution where the president has a power to disapply the Constitution. If he disapplies the Constitution, how can a citizen complain? A resident of that state. As much as a resident of outside Kashmir could not say, why am I made subject to parliamentary legislation when this subject in the state of Jammu and Kashmir is not? And in fact, Malad, we used to always, I remember the late Altaf Ahmad, he used to always have a little joke. He says, you people have lost the right to property, we haven't. 19-1F continued, the equivalent continued under the Jammu and Kashmir constitution. We got rid of property rights. Now, could an Indian complain, could a person outside Kashmir, a fellow Indian, say that my fellow Indian there in Jammu and Kashmir has a right to property? If you take his property, you have to pay him full compensation. But if I am outside Jammu and Kashmir, take my property and you can show me a blank piece of paper and there's nothing I can do.
370 now leads to the abrogation of 19-1F in Jammu and Kashmir.
It does.
But which is not a part of the basic structure. 19-1F has been held not to be a
It is
part
not
of the
as much today. If you are creating a larger equality, the solicitor has developed this point. You've created a larger equality. Where is the question of violating 14? And individuals, Malad, that principle must be extended. Your Lordships have dealt with this problem where the argument was there were prior leases. Your Lordship said, sorry, post-accession, you have what the law gives you. You have nothing else. Now, if post-accession...
Actually, we need not really explore this line
exactly.
much for the reason that this might have impacts on other parts of the Constitution.
That's why, my lord, I was...
The Constitution which create rights in favor of specific groups.
Yeah, my lord, that is why I limited myself.
Whether they're based on religion, whether they're based on caste, on marginalization. So to say that by obliterating that right, you're not affected by a larger equality, maybe.
Malad, 370 operates.
If we accept it in that broad sweep.
No, Malad, that is why I'm saying 370.
Because I don't know what the ramifications.
No, Malad, 370 operates in a very narrow area. Very narrow area. It operates in the context of the compromise formula put in place for Jammu and Kashmir at the time of accession and at the time of its integration into India, etc., etc. And this power was kept to disapply this one provision, this special arrangement. Now, my lord, there is no equivalent in the Constitution. So we needn't go, my lord, the Chief Justice is saying the danger in getting into constitutional propositions in one context and making broader observations, my lord, we don't know what you are trampling underfoot for the future. My limited submission was the principle of limiting delegation by statute, which comes from Article 14, can't apply. This radical change is a reading down of the power to extend laws.
That point you've made, Mr. Salve,
That's the only point which I was making.
That was, yes,
The second point I was making was,
restricted to that level, there is no difficulty.
that's all. And the second point which I was making was, my lord, that here abuse of power is really a power of competence.
And nobody's challenged the provisions of clause 3 of Article 370. That is
Which, my lord, in fact brings me,
part of the original constitution.
in fact, my lord, which brings me to my next point. And I'm going quickly now, because your lordship has seen the point. That this repeated reference to basic structure, my lord, quite frankly, even in some of your lordship's judgments, I find a little surprising. Basic structure was not a principle as a independent standalone constitutional right. Basic structure is the limitation inherent in 368. And constitutional amendments are tested with reference to the basic structure doctrine. But there are some judgments which do say this law not only violates 14 but violates the basic structure. Laws, strictly speaking, if your lordships
laws don't violate the basic structure.
Laws can't violate basic structure. Laws violate part 3 or don't violate part 3.
You know, in 2 judgments, though, we have said that a particular law protects the basic structure. One.
But laws are aligned with the basic structure.
Places of Worship Act in Ayodhya, we said that is in pursuance of the...
Correct. But laws...
The second, we said that the amendment to the introduction of the amendment for Delhi in 239 AA was in furtherance of the basic structure, which is...
furtherance of basic structure...
So there's a little bit of...
let me try and, in my very humble submission, when a law is made to protect civil liberties, 21 is a part of basic structure. A law made to protect civil liberties is a law aligned with Article 21 and therefore aligned with the basic structure. Now, one may in a flourish of language say it is to further. Today, if there are checks and safeguards built into arrest, checks and safeguards built into criminal trials, etc., etc., you may say this is to protect the basic structure, because the basic structure is the trilogy of rights. Now, that is not to say that the law was tested on basic structure.
That distinction you've made, yes, of course, because as a doctrine, it was evolved to test the validity of constitutional amendment.
The problem is, Malad, one thing is to say something is aligned or not aligned with the basic structure. But to say that if exercise of power under 370 can be tested on the basic structure doctrine, I submit is a misconception. 370 itself is a part of the original prestige constitution. And that confers the power to disapply the constitution, the arrangement. If I am right on competence,
Anything else, Mr. Salve, now?
so that is the basic structure point.
Yes.
And the point which we have therefore already made, and I close with that submission, how would your lordship interpret this? The nature of the provision is such, if it confers plenary powers, not in the field of civil rights, not in the field protected by Part 3. But in the area of governance and in the area of constitutional adjustments, your lordship will give it the widest possible. Because the idea is never to hedge in future generations by reading the constitution narrowly. My lord, that is a well settled principle. Last point which I have to make, my lord, is if we are wrong on this, the 356 test. Can a change of permanence be made when a 356 regime is in place? It has two answers. I'll just take 2 minutes on this. This is no longer res integra, my lord. Your lordships have right from Rajasthan and Union of India, Bomai chiseled this law and said, up to the stage where Parliament approves, don't do anything which is irreversible. Thereafter, you may. Because everything in one sense is irreversible. Man. What Parliament does is also irreversible. Parliament passes the budget for the states. It takes over the coffers of the state. What money is spent is irreversible. The money is gone. But that's the way it is. The president may not dismiss people, appoint people, create institutions, remove institutions. The governor may do, the president may do under 356. Those are for those people irreversible actions. That is why your lordship has said 356 is draconian and should be very sparingly used. If the unfortunate circumstances require that for a defined period of time, the system of governance is changed under 356. If those unfortunate circumstances exist, and a very narrow area of judicial review is permissible, it doesn't arise because there is no challenge before your lordship, a bald prayer without the necessary averments, the challenge. Then, my lord, one is to accept the consequences of 356. But that's in the alternative. If I'm right on my construction, my lord, of the proviso, quite frankly, minus the Constituent Assembly, it fell away. So you just added the state legislature and then you acted for the state legislature. Nothing my lord, dramatic really happened. If one ignores that also, if we are right on the proviso, then none of those questions arise. That, my lord, is the submission, unless there's something else I could assist your lordship.
Thank you, Mr. Salve. That could be all. Thank you, Mr. Salve.